Hey guys, I went ahead and started this early because they are streaming in Judge Feist's courtroom. I don't hear anything yet, so I'm going to see if I can fix that. But let me get it over here to comments to make sure you guys can hear what's going on here. And now I'm going to fiddle with this a little bit and see what's up. Okay, the volume is turned up. And I think it's got it running. So maybe they'll actually do this, huh? Today. It's the right judge, the right courtroom. And it was scheduled, it looked like to me, for the start of court today. But of course, that doesn't mean he's the first guy up. So we will see. Looking for any movement by any human being to make sure this is live. So again, sorry for the technical stuff here, but I went ahead and started it when I saw this was on. It doesn't look like anybody's moving. Okay, and I saw somebody's arm move, so this has to be doing something. But I still don't hear anybody yet. They may not have started. The defendant here doesn't look like he's saying anything or hearing anything. Yeah, I'm way caught off guard. And I'm sure I got full coffee and stuff here, but I opened this tab up and it just sits there refreshing, and then it actually started showing something. So I'm like, well, hey, wait a minute. Because just when you expect court to be delayed again, it goes early. Yeah, I know that's not Brooks. What happened is the court started streaming, so I went ahead and started the stream. His time is set for when court opens. That doesn't mean that he's going to be the first person that they roll in there. Not sure what's going on, with this defendant. So we'll just have to see what's up. Yeah, he's trying to send us some Morse code message, but it does show me at least this thing is running. So I think they're probably early too. So I mean, I see one of the attorneys looking at his phone and stuff, so they may not be doing anything. Yeah, that's not Darrell Brooks. That's the right judge, the right courtroom. They haven't wheeled him in yet, so they may just be doing somebody first. So Darrell Brooks is convicted of the parade attack, but this is in Milwaukee. This set of cases is actually when he was shooting at a relative and somebody else, and then he was also charged with felon in possession of a weapon. So that's what this is. And then he still has the Erica cases. Those, we tried to stream that earlier, but it got delayed till later. So he has other cases. Yeah. I'm ready. So if we do get some audio and I hear Darrell say something that I don't agree with, but I don't want to interrupt it, I will call back to this situation. So I got some props here. Yeah. Well, he's leaving. This is happening. The only thing that concerns me is no sound, but they may not have it turned on yet because I was hitting these buttons so fast that I wanted to make sure it does say screen audio is on this thing. I'm switching up people. People are doing things, so I'm not sure if it's me or you when we're not hearing the court. Okay, that's the issue there. So I'm going to stop sharing this court thing for a second and then reopen it just to make sure I've got the audio in. Okay, so again, this is the right courtroom. This is the right judge. Just because he's called, doesn't mean he's going to be the first, second, or third person up. They roll all these people through, I'm sure. Thank you. Accidentally booted out. All right, I'm going to stop this screen and then I'm going to bring it back. And I want to make sure I'm clicking on share audio. Yeah, it's on. So let's bring it up a little larger here. I suppose that's exactly what happens on this question here, because they do an order to produce him for the hearing, to bring him to court. And then, of course, he's rolled in this wheelchair. So I don't know why they're not talking yet. They may just be handling things that are a little less formal at this point. I mean, obviously people are chatting, and looks like they're checking out their own stream. So again, he is the right guy, right judge. I mean, right courtroom, all of that. I just don't know why we don't hear it.
That he has some of the discovery, doesn't have an offer, so we're going out about 30 to 45 days for a status date.
Okay, thank you.
Are people hearing this? I think we got the audio.
So 9 a.m. July 14 or 21st?
I could do either.
Either's fine.
14?
Sure.
9 a.m. July 14.
I think that's just security. He is a convicted murderer after all.
All right, so July 14th at 9 a.m. That will be back here in room 113 of the safety building. Mr. Means, good luck to you. Try and stay safe. Try and make good decisions.
Thank you.
Thank you.
It's sometimes too late, Judge, but good sentiment. Make good decisions.
All right, are we ready on McKinney?
Yes.
So remember, we haven't really hit the time yet where Brooks is supposed to be there. They just started streaming early, and I didn't want to miss it. And I don't think I've missed it. You know, I don't know. Maybe he came in there before they started streaming it. But as soon as I saw that,
I think, Brian, I think we're just going to do scheduling without him.
I went ahead and made it live. I think it's just security, since he's a convicted murderer.
This is State of Wisconsin versus Darrell McKinney, case 23 CF 755.
They got one name right.
The state appears by Owen Petresky. William Kerner appears for Mr. McKinney, who is in custody, and I don't see him, but I can waive his appearance because I spoke to him yesterday.
Sweet.
All right. We are on the calendar today for scheduling. I think we were last in court on May 1st, and we set the matter over to give Mr. Kerner and Mr. McKinney some additional time to determine their posture. So, Mr. Kerner, how does Mr. McKinney want to have his case calendar going forward?
Mr. McKinney, at this time, even though my back injury kind of kept me away from completing everything I want to do, would like to set this for a plea and sentencing date because I have such confidence in the state's ability to be reasonable. I believe we will resolve this.
How refreshing. Complete agreement on all parties.
Yes.
I don't know if anybody saw how they T-Rexed Taylor Shabusiness for her most recent hearing after she attacked her lawyer last time. This is the right courtroom. Just because he's not up yet doesn't mean he's not coming up or hasn't been up or whatever. I mean, they run through these people pretty quick, so we'll just watch and see. At least it's streaming this time.
At 2:30, that'll be an in-person hearing in room 113 in the safety building. Thank you.
Thank you.
So I could turn myself down if you guys want the court to be louder. The court volume I've got at max.
It's here, right? Or is it someplace else?
113 in the safety building.
That's what I thought you said. I'm
Yeah.
sorry. All right.
He should change it to past tense. I'm going to try and talk like a golf commentator, so I'll equalize with the court here. Yeah, you know, the last times he did these, he was super friendly to this judge. And the judge told him to make better decisions. So, you know, they don't just schedule Darrell Brooks when they do these pretrial conferences. That they probably do a bunch of them at once, since they're so short and all that, and they just run through them. So he's probably coming up. He wasn't scheduled till 10.
Thus the calm.
10 at our time, not fake Wisconsin time.
Yes. 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 All right.
Sold.
What about you? Do you have any trials this week, Mr. Court?
No, I'm in charging this week.
Ooh, okay.
Had trials the last 2 weeks though, so I've been busy.
I don't know how they do it there, but sometimes they'll go ahead and call all the people that are associated with the lawyer, so the lawyers can do their people and then leave. They don't have to sit there all day.
So did we produce Brooks?
Oh, here we go. Here you go. Did we produce? Brooks?
Generated. At least according to my notes, I didn't check the CCAP.
He did not. He withdrew that, I think.
Okay.
Yep. Caught me off guard, but here we are.
I presume he's not in back yet. Is he a special run? Okay. Well, we have Mr. Hampton here. I just saw Mr. Moran.
I'm gonna try to grab him before
You got time.
Yeah.
start popping off.
So,
Brooks is a special run, the judge said.
What happened with the Zoom?
don't believe everything you read, Brian.
Good advice by this judge. Don't believe everything you see either.
I had Zoom in my notes too.
Pardon?
I said I had Zoom in my notes too.
So somebody said that there's just some confusion over where Brooks is.
Let me know when you do.
Have you talked to Darrell at all?
Last time I talked to you about 3 weeks ago.
Okay, he's here.
Okay, he's in the back.
Not back, he's being brought here.
So I think they're talking about him and saying he's in transport.
Well, we don't really have anybody right now. Is there any way? Come up the road. Yeah, I guess I can hop on Zoom and talk.
So now they're trying to figure out if they can stick
Okay.
another defendant in there since Brooks isn't here yet.
Judge, did you get anything from Christopherson about Mr. Bowen?
Yeah.
He's
I just found it this morning.
The trial date is July for this case.
To Christopherson, right?
Yeah.
Yeah, okay.
Sorry.
Yeah, I just found it.
So he committed these offenses July of 2020, and it was the delay in these that allowed his bond to be lowered, and that got him out on the street. So these cases suck. They should have prosecuted this a long time ago, and maybe he would have been in jail.
All right.
I'm going to make it even bigger because I'll be in this little witness chair here. So for people coming in, Brooks is in or out, and they have run out of other defendants to do. So they're just telling stories to each other right now. Yeah, I posted the dates up for the other trials. So Erica's trials were moved to pretrial conference in July, trial date August. Or originally would have been this month until they booted it out. I don't know what they're going to do to this today. So this is due for trial in July. Yeah, it did everywhere, and I think it was even mentioned in the record as a reason for one of the delays in his case here. A lot of people were put back out on the street when they shouldn't have been all over the country. He was just, maybe the worst example of that, but there was a lot of violence done. People who.
Yeah. Are we ready? Okay. Okay. We can bring in Mr. Yeah.
They have to get the wheelchair ramp for him ready. There's somebody else. Again, they're trying to get Brooks there, but they're looking for other defendants to process. They've been doing some earlier too.
Good morning, Mr. Thompson. Good morning. Great. This is State of Wisconsin versus Pierre Thompson Sr., case 23 CF 1385. Appearances?
William Behrens appears on behalf of the state. Really? And Mr. Pierre Thompson appears in person with attorney Michael Moran. Good morning.
Good morning.
Sweet.
We are on the calendar for scheduling today. Mr. Thompson went through preliminary hearing court on May 16th, and we were set today for scheduling. Mr. Moran, have you received discovery materials and or an offer letter?
So Judge, we have received both discovery and an offer letter at this point.
Hold on one moment. I apologize. There's someone whose device identifies you as Lisa's iPhone. Can you tell me who you are and which case you're here for?
Darrell Parker Bell.
All right. I'll put you back in the waiting room. When we call Mr. Parker Bell's case, we'll bring you into the hearing. Yes, sir.
So yeah, see, they have a lot of these people teed up. It's not just a special day for Darrell Brooks because it's just a pretrial conference. So there's lots of defendants, and they did call him already, but he was still in transit.
Okay. All right.
The dude is super dangerous. Yeah. Did you see Taylor Business when
No
they
worries.
T-Rexed her
All
arms?
right.
He's
Sorry,
one step
we're
worse
back on
than
the
that.
record. So how does Mr. Thompson want to have his case calendar?
So Judge, we would just ask for another adjourned status date. I'm working through the discovery right now, and I'd like to continue to negotiate with the state.
right.
I
so
had
I'd
this
ask
one
for another
queued up.
date in about 30 days.
Always bet on
Okay,
a
we'll
delay.
give you that date.
Just another adjournment, Judge. That's all we need. If we could just put this off, that would be great. Thanks.
July 13th.
Sounds good.
That was the 14th, you said?
13 or 14.
13 or 14? 13th, please. All right, the 13th at 1:30 works for us too.
All right, July 13th at 1:30. That will be an in-person hearing in room 113 in the safety building. Good luck to you, Mr. Thompson. Try and stay safe. Try and make good decisions.
Thank you, Judge.
Thanks.
That is some wild wallpaper behind that, Judge. Like I can't stare at it too long. It must be there on purpose to disorient people in the audience.
I just got information. They don't need to, if we're putting on Zoom, they don't necessarily need to book him in as long as he gets searched. So we'll have him searched and put it in Zoom.
Excellent. Thank you, Brian.
I don't know why. A police officer was yelling at you?
Huh?
A police officer was yelling at you?
No, somebody that was at stop in and say
Oh,
I think that's correct.
110 is open. Yeah, 110 CJF is open. Yeah. Mm, Yeah. Yeah, it's like why they're calling you, complain about DA's office.
better her than calling us.
We have Mr. Rakestraw.
I'll plan on zooming in for Mr. Bowens.
So actually, so
So Brooks was in transit, so they've been processing other defendants and things. It's not, again, not a special day for him. There are a lot of cases to be scheduled, and this is his supposedly final pretrial conference before trial in July for shooting at 2 people and possessing a firearm when he was a
so
felon.
yeah, if you're fine with this, we can, and is Bowens in or out?
I'm not open right now.
Should we, he's aware of,
Yeah, he hasn't shown up yet.
so
He was
Bowens is
being,
aware of
he's
my
in
request.
transport, so he's somewhere on his way.
All right, so yeah, let's just do it by email. On Bowens, we can give them a new final pretrial date by email. All right. So that's gonna be, if we're set for trial July 10th, I'm down the week of the 3rd, you're unavailable the week of the 26th. And I'm only up, Monday, Tuesday, and Wednesday this week. And then next week's a 4-day week. So, our,
What's the day of the 22nd? Thank you.
Like that AV cart they've got back there.
all right, so it looks like we now have Brooks, Rakestraw. Well, he's in, at least there's a booth that's entitled Brooks, so we'll see. He might not be in the booth yet.
So he's in some booth.
Yeah.
Nicole from WCS for Parker Bell. He said in the thing or?
Yeah, she come in.
This will,
Good morning.
if you look at the top left, you can see it says Brooks there on the blue screen. So they've got him somewhere anyway. He may not actually come into the courtroom. He may still be looking for his birth control glasses so he can see the proceedings clearly. So certainly a treasured possession at this point. Those fantastic glasses. He may be exercising his right to his constitutional right to a box fort and demanding boxes to be behind. Yeah, what's up with this dude? Yeah, he shot at his nephew after a fight they had that he lost, and the female that was accompanying the nephew was also in the vehicle. Thanks, and you too. Yeah, nobody tells him what to do. So the police report said there was some fight over a cell phone. He lost, Brooks lost. So he shoots at his nephew and somebody else. And then when the police come get him, they find him inside on the air mattress next to a Beretta handgun and a bag that looked like it had meth in it. And he was taken into custody without further incident. But due to the court delays, his bail was eventually reduced, and his mother posted that. And then he was out so that he could then attack Erica and get out for that, and then attack the parade. Well, it's hard to say since it didn't hit anybody, but the vehicle had his nephew and the female in it. I'm not sure how many rounds he fired. I usually like to try to refer to him as scumbag, although that seems to bother some people. Though most of those people are gone at this point.
Right.
Yes, the air mattress king. Did a video on that earlier and how he lost that fabulous lifestyle. I used to do that a lot, and I don't really do it anymore. I've got at this point, I've got everything like I like it. Yeah, at current, he's still representing or being represented by attorneys. I think they are the same in all the cases. He was making noise about representing himself. That went away. It's not beyond him to bring it up again at any point. So who knows? Good morning to Africa. That's a big place. Well, it's a beautiful country there. Well, she still runs trials. I mean, you can watch her on her streams, but this is in Milwaukee, so these are two different judges. This set of cases has the male judge, and the Erica cases have a female judge.
Come down at 10:30. It's there's a statute called the Interstate Act to compel the production of out-of-state witnesses. And as the presiding judge of felonies, I hear those. So if, let's say, you were witness to a case when you're down in Florida, right? And you've moved back up here. Florida court has no jurisdiction.
Yeah, I'll try and comment on that. I did a little bit in the weekly docket, but I'll do it again once they're done with this, because it's pretty complicated.
Make a finding that you're a necessary witness and that it wouldn't cause undue hardship for you to appear at the trial.
I'd say that's accurate.
And then the Wisconsin court issues an order ordering you to attend the court.
Good morning to Great Britain.
Florida has to provide you with transportation if you're immune from stipulated criminal process while you're and
Thank you very much. I really appreciate it.
since Chris Sanders is going to take over as presiding judge, he wants to come down and see what they look like. I believe they put you on a flight.
Well, it's not surprising Brooks would create some kind of delay, huh? Find some way to do that.
It'd be more expensive to pay you mileage.
Dang.
You know, have to pay hotels and stuff. So
I still hear him, but they took the video off. Maybe that'll pop back up here in a second. I was trying to pay attention to comments in addition to the judge. Didn't he say something about 10:30? Or they maybe taking a break until 10:30? I don't know if anybody heard that or not. Was reading. These days, far be it from doing two things at a time, I'm lucky to be able to do one thing at a time. Yeah, I could see him do this again. as bad as he is, I mean, in terms of courtroom, obviously his time outside the courtroom is as bad as it possibly can be, as bad as he was in court. He's not unique there. There's been some pretty horrible people in court. So I'm thinking maybe the judge said they would come back at 10:30. Or he said something about 10:30. And if he's out of defendants and they were trying to get Brooks, then maybe that's what he's doing. So it refreshes every few seconds. That's how it started the stream early, because it just popped up all of a sudden. So I'll tell you what I know about this Chandler. Well, I'm still talking like a golf commentator, and they're not even doing anything. Anyway, yes, Brooks' appeal attorney, Michael Covey, he's the same appeal attorney for Chandler Halderson. And it looks like Chandler Halderson's case, that attorney is going to file a no merit report. There's a notice of that in the appeal docket. I don't know if he's actually filed the actual report yet, because when I looked at it, it said due by June 20th, but there certainly is indication that's coming. So if the attorney reviews the record and doesn't see a sound basis for an appeal, then they can file a no merit report, which says, I looked at this, I don't see any reason to appeal. Now, if they do that, the person who they're representing can disagree with that, argue and make their own argument about it. Also, the Court of Appeals will look at it just to make sure they don't think that the lawyer missed anything. So various different things can happen at that point, but typically the no merit report stands, and then that's it for that appeal. So then the question is, well, what happens after that? Can you ever appeal again? Well, you basically are entitled to the one paid appeal. So if that doesn't work out, it's not necessarily the case you can never appeal again, because the law is full of exceptions. And think about, for example, this isn't applicable to Brooks, and not Halderson either, but what if you found some evidence, 6 years later that you didn't know about at trial that shows you're innocent and things like that, and you want to petition the court for that, or something else that you didn't know at the time. It's not your fault, you didn't know it, and you should be able to appeal that. So there are exceptions to that. And plus, prisoners just sometimes file appeals just because that's what they feel like doing. What else are they going to do? And eventually the court quits considering them or whatever. But you look at Mark Jensen in Wisconsin, and he appealed all the way up through the Wisconsin courts to the Supreme Court there and didn't win. But he did a parallel appeal over to federal court, saying his constitutional rights had been violated, and he won there, and he got a new trial, right? He's just convicted again. So he lost and lost and lost, but finally he won. So again, I'm not saying that's the situation for Brooks or Halderson, but just because there's a no merit report on this appeal doesn't mean that nothing could ever come up, or the person won't file paperwork and stuff like that. But in terms of at least what I saw when I looked it up, the one paid appeal, and that's the end of it. If the no merit report stands, I mean, occasionally, if they think there's a mistake or whatever, they can order the lawyer to look back at it, or they might switch lawyers or whatever. But it's pretty unusual. And even the no merit report for the court to review, it takes a long time. So for people tuning in, I missed what the judge said, but they were waiting on Brooks, and I think he said something about 10:30. So I'm thinking that he just stopped the stream and took a recess or whatever, but I'm not sure. And I guess they could say that, but my recollection of the police report, and I haven't read it lately, is that the female saw him come out of the house, look around to make sure nobody was a witness, and then watched him shoot at them. So they weren't next to each other. They were trying to get out of there. I mean, I guess in theory this could happen, but I don't think it's going to happen. And for example, he made it all the way to the end of that case, right? So if he wasn't competent to represent himself, or his behavior is so excessive he shouldn't have been, then he shouldn't have made it to the end of the case. So I don't think so. I think it would depend on how he behaves here and now. And they have to be careful with that. He's got a right, like everybody does, to represent himself if he wants to, unless he forfeits that. So, and even with the stupidity that he did in the courtroom, there's plenty of other sovereign people who've done as equally as dumb arguments, and some defendants, even when they're represented, highly disruptive in a courtroom. So I heard 10:32. That's why I'm thinking they maybe adjourned until 10:30, because the stream stopped. and they had started earlier than I expected. So I wasn't quite ready. I was trying to do some litigation things this morning. Well, they kind of control their own docket. I mean, this case, he did the shooting in July of 2020, and it still hasn't been tried yet. So this stuff is not fast. Let's see. Yeah, maybe I covered the Halderson thing okay, or at least to a degree I know about it. Sometimes you can pull the documents on appeal cases in Wisconsin, and sometimes you can't. Well, as an honorary American, an actual American, I think attorneys here are often referred to with words or adjectives that are 4 letters. And there are several that appear to be interchangeable. Yeah. Yeah, good point. I thought I heard him say something about 10:30, but yeah, that wouldn't make any sense for us, would it? I think they're on the hour behind. Anyway, we'll wait till then and see if he comes back up, because they had waded through a bunch of defendants this morning. When they started the stream, they were working other people they had because Brooks wasn't there yet, and I think they ran out of people while they were waiting for him. So my operating theory right now is that they're on a break. Well, I did a video on the actual legal aspects of the charges that he faced in New York, and based on the feedback from that, I'm not interested in covering it anymore, because I'm not aware that putting a video out on that helps anything, just to cover the legal point without being on his side or not on his side, because the people just come into that forum or against him, and the rest of it didn't seem to matter at all. So there's plenty of sources on which side people can look at that, either for information or just to be mad one way or the other. Yeah, so I think that's correct. And they're an hour behind where I'm at, which is 10:19 here, according to my computer. So if he did say 10:30, then they would be gone for quite a while, and we won't sit around and talk that long, because I'd be wasting your time, which I was accused of the last time, wasting everybody's time, and I couldn't control it whether the court streamed it or not. So what we'll do is we'll just wait till, or what I'll do, at least, you can do whatever you want, is wait 10 more minutes. And if they don't come back, then I'll probably crank this puppy down. So you want to sit around waiting, because you don't want to watch me do paperwork. And then if it does start up again, then I just would redo the live thing, I guess. But I don't know. We'll give him a few more minutes. But in theory, he was in transport. Now, one thing that somebody mentioned earlier is long gone, I can't bring it up, is, is he causing trouble this morning? Maybe for them to be taking this long to do it, because the judge certainly thought he would be there at this point. And his lawyers were there too. So I appreciate that. It's not a universal opinion, but I didn't get any more out of staring at this Milwaukee Circuit Court screen the last time than anybody else did either. You don't control what they did. The judge controls that. So we'll give the judge a few more minutes and see if they come up with Brooks or not. What I'm aiming for is the half-hour mark. And if they don't start up in a minute or two after that, then I'll shut it down and come back if they come up. So maybe we'll go over this for a minute again. So what's up today is his cases for shooting at his nephew and a female that was with the nephew post-fight with Brooks, which apparently Brooks lost. Something to do with a cell phone, purportedly. They try and leave. He comes out, looks around, according to the witness, shoots at them, and then they leave. Police come because of the shot spotter. And eventually Brooks is there and the mother says, yeah, he's in the house. They go into the house and he's on an air mattress and with a gun and a bag of what they thought was meth. So they arrest him and they charge him with 2 counts of reckless endangerment and felon in possession of a weapon. And then his case was delayed, and eventually had his bond reduced and was able to get out. And that's what put him back on the street, unfortunately. Really terrible situation. And let's see. So then he was due to have his Erica Patterson cases before, which is, it's battery, intimidation, and bail jumping in that case. But his lawyers requested an adjournment that day, and they got it. And of course, it wasn't streamed. And now those cases are behind this one. So that pretrial conference would be in July and trial in August, whereas this set of charges should be pretrial conference today, trial in July. That's the status of things. And we've argued before, and I respect everybody's opinion that should they even bother to do these cases or not. I think we've heard, the solid arguments that every side has on that. So, in terms of his appeal, the lawyer's got to look at the record. You can't use the video. You got to use the transcript, which is still being prepared. And so what happened in trial, is there something that was a reversible error? I didn't see it. But then other aspects of the trial, should it have been moved to change of venue? Should that have been granted? The composition of the jury, things like that you could make an argument out of. I don't think the judge made a mistake in those things, but whenever you have to weigh factors, that's, if you're a lawyer looking to appeal, you're going to look into that and see, can you argue that? So where did we go here? I'm trying to bring your comment up. What's up? Okay, so yeah. No, that wasn't the one I was looking for. I must have missed that. This one. The report I saw said it was stolen too. And of course, that'd be easy to believe because do you think he buys anything? Now, in terms of whether he's going to be on Zoom, he was supposed to be transported there. And then just before the court shut the stream down, they showed a little box up on their TV that said Brooks on it. And so the judge said, well, they got a box for him. Is he ready to go? But he wasn't ready to go. So then the judge said something about 10:30, which confused me because I was thinking about 10:30 here, and then the stream went off. So maybe it comes back on again and maybe it doesn't. It refreshes itself every few seconds. But we were in the right courtroom, has the right judge, had Brooks' lawyers. They said several times they were waiting on him to be brought before them. And then the stream went off. So we'll have to see. I guess that's maybe a good one for people to answer each other in the chat. I don't know about too many favorites there because he was so ridiculous throughout it. I mean, there's certainly notable moments in it of the stupid things that he did. But I would get just more mad about it. I mean, a judge needs to have an even disposition, and I generally do, but I would probably run out of patience with that joker before the judge did. Yeah, I definitely also enjoyed that moment. That was great. That was awesome. So many bad things should have been said about him that weren't, and part of it just to keep the proceedings moving. Yeah, I think she also, when he said attack it agreement, finally said, I don't know what you're talking about, attack it agreement. And I've had several people correct me when I've said tacit agreement. I say, you don't know how to say that word. But I am just saying it that way because of Brooks. But I'm not going to argue about it because there are many words I'm sure that I mispronounce on a regular basis. So again, as people come and go and all that, there's more people here now. So Brooks' case was called. He wasn't there yet for transport. They had ran through all the other defendants they had, I think. His lawyers were there. The judge was there. The judge was trying to get him present for the hearing, which I'm sure he's demanded. Otherwise, you necessarily have to be there for that. I mean, they actually had one earlier where the lawyer said, well, we can waive his appearance because I talked to him this morning. I guess some surprising thing to me in the trial was when he did start his defense and he started calling witnesses, and I'm like, what's this guy going to say for him? And then the guy was like antagonistic towards Brooks, and then I realized the people he were calling weren't beneficial to him. They're just people he was calling. It just made the state's case even stronger. So one thing I thought about doing for the poll for the end of the week is what people think about jurors after a case is over making comments to the media or in public. Should it be banned or not? Because it seems to put trials at risk, at least in people's opinions. Okay, guess what, people? We are coming back live. We'll go back into golf mode as the judge approaches the tee. All 4 boxes are currently lit up. Let me get the screen bigger here. I'll return myself to this empty juror or witness chair here. I think that's certainly the wise policy. But the fact that they do, and they sometimes misstate things, and it
Good morning,
doesn't
Mr. Smith.
mean the verdict's going to be thrown out. But sorry, I need to cut you off there. Oh, they got a fresh defendant. They got a new bus load in.
This is State of Wisconsin versus Leon Smith, case 23 CF 582. Appearances?
State appears by Josh Maffey. Good morning, everyone.
Morning, Your Honor. Attorney Frederick Clements appears on behalf of Leon Smith. We are each present in person in your courtroom.
Good morning. We are on the calendar today for a final pretrial.
Yeah, ultimately, I agree.
Smith's case is currently set for trial on August 7th. I believe that this is Mr. Clements' first appearance on the matter. We were last in court on May 1st for scheduling. Attorney Matt Ricci represented Mr. Smith at that point. Looks like Mr. Clements filed a notice of retainer on May 8th. Mr. Clements, have you received the file from prior counsel?
I have, Your Honor.
All right. At this point, is Mr. Smith still in trial posture?
Your Honor, I've made several counter proposals to the state's offer. Of course, my counter proposals are extremely reasonable, and of course, the state's, obviously are not. So I'm just kidding. I've
Good
made
lawyer,
several
Mayor.
counter offers to the state, which the state to this point
Don't forget to tip the
indicated
wait
they
staff,
are
people.
not inclined.
And he'll
to
be here all
accept.
week.
So, bottom line answer to your question, Judge, is yes, we are prepared to go if we need to on August 7th. It's kind of a shame in a way because I don't think there's too much dispute about the facts in the case. The real issue is what is the proper remedy. But at this point, if we have to go to trial, we'll go to trial.
All right. I will let you know that effective July 29th, this calendar will be assigned to the Honorable Laura Crivello, Branch 36, and heard in room 316 of the safety building.
The safety building.
The trial date is August 7th. I don't see that there were any trial documents filed. Given what Mr. Clements has said, do the parties think it would be useful to have an adjourned final pretrial date closer to the August 7th date?
Oh, let me get this banner up, yo. This is always a good one to have on standby.
All right. Why don't we set a date for an adjourned final pretrial? I would have set this date just because on May 1st, I wouldn't have been able to provide the parties notice about who the assigned court would be on August 7th. So now we've accomplished that.
I guess the options would be what, July 31, August 1 or 2.
Yeah, I've got them maxed up
And that would
on
be
my
the
end.
judge, apparently.
It's effective the July 29, yes.
I have 2 juries scheduled on the 31st, so can we aim for later in the week by any chance, the 3rd or the 4th?
It's a male judge for these cases, female for Erica.
August 1 and 2, sorry.
Or you can go the prior week for me.
What about-
Before you?
Yeah.
Oh, I thought you wanted it before.
No, I don't think
Cabello.
it's, I just
Oh, sure.
wanted a little closer to the trial date, but it doesn't necessarily.
Me, July 14, July 21, and July 27 are all good.
27's the best for me.
Welcome to scheduling conferences.
Pardon? Yeah, and since I don't have anything to move, I think like that they'll move their stuff in, so you can, I'm gonna schedule on July 27th and.
Okay, just sparing.
if
Yeah.
the-
He has a female judge on the Erica cases, but those didn't
July
stream. But
27 in the morning?
they're due in a month or so
Earlier,
from here.
1:30? Or do you want morning or afternoon?
Morning would be better.
Sure, thank you.
There are a few here.
We keep the afternoon like that'll be perfect.
So 8:30, July 27th.
Sure.
All right, next hearing will be final pretrial, July 27th at 8:30. That'll be right back here in room 113 in the safety building. Good luck to you, Mr. Smith. Try and stay safe, try and make good decisions.
Thank you.
Brooks was really testing the lightning resistance of that building.
Thank you, Your Honor.
You're welcome. All right.
This is always true. That's why they say a good lawyer knows the law, a great lawyer knows the judge.
Owens is in custody. Oh, we're adjourning that by email. I'll get you the date as soon as
Judge, do you mind if I tune in by Zoom for see if Jimmy Grant shows up at 10:45?
No, I don't mind.
Thank you.
That dude's out of there. Screw this. I'm gone. Putting my stuff in my
Wanna
little
wait a
briefcase and I'm
couple
getting
minutes
out of
on
here.
Mr. Parker Bell's case, because we have Brooks and Hampton and Rakestraw in a breakout room. I think that'll be relatively quick.
So he just said Brooks is with his attorneys in a breakout room. Breakout being
All right,
figurative.
thank you.
And then he said it will be pretty quick. Be cool if it was a breakout room. Though. And then when he breaks out of it, he finds himself in another jail cell. Kind of Inception like. Yeah, so Brooks he's talking with his lawyers right now. Probably about, I don't know, you can't see from this angle what kind of flag they have in the courtroom, if it has fringe on it or not. So I don't know if this is an admiralty court or not, and whether in fact there is subject matter jurisdiction. I haven't seen the state of Wisconsin present in the courtroom either, so these could be things that Brooks is going over with his attorneys. I guess it depends on how you were involved in it. Yeah, I think they actually had the attorneys in the room earlier. So, but they had Brooks on a box, so you could be correct. But thank you for correcting that. Well, I'm informed that's what they're calling Zoom. To me, it was the more exciting theory that he might try and use a file to get out. Yeah, she seems to really like fussing about the lawyers rather than wanting to do it herself, although she has declared herself an expert on all amendments of the Constitution. You don't really get letters much in the mail anymore, at least I don't. So her letter is addressed to the whole world, which includes me. I appreciate that aspect of it. This would be interesting. I could see him waiting later than this, though, to try and fire his lawyers if he really wanted to screw the system up, generate another hearing. Yeah, it got smashed as an unfrozen cave lawyer, figuring that breakout room was like the old school days when you'd actually have them in a room next to the courtroom talking because his attorneys were there, I think. But you're correct; they did have Brooks' name up on the screen, so he may be appearing by a Zoom situation. She has good penmanship. I mean, you have to give her that. I don't know that that's going to mitigate her case much, but that is laudable. Yeah, she said, "Hey, Judge, what's your cut of the
Let me see if I can.
YouTube revenue?"
The breakout room.
Okay, thank you. I think here's where everybody has dunked on me because I think the judge is in fact looking for the Zoom breakout
Well, I
room.
guess what I'm gonna ask is, can I call it and then put them back in a breakout room afterwards? So I'll try this.
He's dancing on the keyboard now. He's trying to enhance the image. He's hacking into the system. Yeah, if she is sober. That was pretty good. But I mean, Sarah's is more old school, all the way back to colonial times and things like that. And a nice flowing penmanship. Brooks is better than mine. I have to slow down if I write something, if I expect to be able to read it myself later. Yeah, that's the case that shouldn't go to trial, but due to the idiocy there, perhaps it will. If she really does insist on exoneration because of being a battered partner, then I suppose it would go to trial. The DA is not going to give her that, I don't think. Still in golf mode. Yeah, that little thing you had was pretty small. So I have a regular size pin here, but I almost often will carry this one because it's even smaller.
I sent a message saying, asking me if I could call your case and then put you guys in the breakout room again afterwards. If you needed done.
So right now the judge is trying to figure out how to do the Brooks case. So here comes that's one of the lawyers right there. So they may have a Zoom breakout room that actually is another room in the courtroom. So it's like 4D chess because it's a Zoom breakout room, but it's also a room next to the court, which is a breakout room. So we're not this advanced in North Carolina. We just started electronic filing in 4 counties recently. It's gone okay. And now you can start to pull up documents and things like that on cases here in Woke County and some of the other counties. And then they're supposed to roll it out across the state, the whole state. Yeah, that's what I saw. So you can be less stabby. Can you imagine giving Taylor's a business anything? They could penetrate anything? I don't think so. No, she got her side requested a continuance because she was still trying to get an expert who would testify that she was a battered partner for purposes of self-defense. This could be true. So the judge is, and I think one of Brooks' lawyers actually came back into the real room and not the cyber universe breakout room, which is also a real room, perhaps because he's there with his lawyers. And the judge is trying to get the Brooks case called. So I guess they're not rolling him into this courtroom. I don't really know what's going on exactly because I think the lawyers are there with the judge, which means Brooks is there, but yet they're not bringing him into the courtroom. Maybe they don't, it's not wheelchair friendly. Yeah, I agree. See, to me, it is still a lot about the suitcase and a lot about the fact that the guy died in it. I still feel like that's relevant to
Okay,
the case.
I'm gonna call Parker Bell.
Okay.
And then okay. All right.
Okay. See, I think that's one of his lawyers there on the top left. Isn't that one of Brooks' lawyers?
The other one's outright, and then we'll just do that one.
Okay. All right. Can I talk to the two of you briefly while they're bringing out Parker Bell?
Well, they are going to talk to Brooks. They're just taking a long time. And part of it was apparently was discussing things with his attorneys, which is interesting. But I think his attorney said earlier this morning that he hadn't talked to him in a while, so that could make sense, I suppose. And then they were trying to calculate how to do this breakout room. And then could the judge talk to them and then call them back and get the case over with? And now he's talking to somebody else. So this is just isn't unusual for scheduling stuff. I mean, you have a bunch of cases and you have that set up, and some of them go fast and some of them don't. Yeah, I mean, I could see that. It kind of makes me, I don't have a tinfoil hat in here with me, so I'm going to object to my own statement I'm about to make and say, I wonder if they delayed the Erica cases because he was telling them he did want to do that and they want to get this case over with first if he wasn't going to fire them for this. That would be an interesting conspiracy we could think about. All right, let's see. The judge is back on the bench.
Yes. Okay.
So we are
right.
just,
Okay, that'd be fine with me.
well, they probably have other clients they're doing today. Usually the defense attorneys have a bunch of clients and you try and do them one after the other.
Okay.
All right.
Good
Yep.
morning, Mr. Parker Bell.
Mr. Parker Bell. Scooted him up. That's nice.
This is State of Wisconsin versus Darrell Parker Bell, case 22 CF 811. Appearances?
Kent Levern for the state.
Your Honor, good morning. This is Mr. Darrell Parker Bell. He's in custody. He's present in the courtroom with Nathan Oplendaps.
Good morning. We are on the calendar today for a hearing for the court to make determinations as to the appropriate placement of Mr. Parker Bell and the length of his commitment.
So this isn't Brooks
Did
yet.
speak
This is
briefly
Parker
with
Bell.
the lawyers before we went on the record, just to confirm that that's the purpose of today's hearing. I do have two individuals from Wisconsin Correction Service who wrote a report for the court, who are present if there was information that was needed or questions. My understanding is the parties are prepared to proceed, and Deputy District Attorney Levern, my understanding is the state's in compliance with victim notification, and there is a victim who wishes to address the court today. Is that correct?
That is correct.
All right.
The next one's
Anything
free.
we need to do before we bring that individual in?
Oh, he could come in now if you'd like to hear from him now.
She's working
I
her
guess,
punch card.
I'll allow you to make a presentation and do it in the order that you prefer. Okay.
Okay.
Do you want him now?
Okay, well, maybe I'll just set up a few of the facts here and then bring in Mr. Holmblad, and then after his statement, then I'll make a few other statements to close out. Okay.
So I guess I'll do Brooks after this. He's still talking with his lawyers.
Obviously, because of a very traumatic incident that took place in February of 2022. We deal with traumatic incidents in this community, as does every community, every day, unfortunately. This is one that's quite unique in nature, and it certainly underlies the entire reason why we're here and what essentially the next appropriate step should be here. The reality is that as we now know, a gentleman named Keyshawn Thomas died in the custody of the District 5 police just a couple of days before this incident on February 25th, he was a close friend of Mr. Parker Bell, and Mr. Parker Bell was grieving his loss. This is indicated in the criminal complaint, and there's really no dispute about this. And Mr. Parker Bell then dealing with his grief, essentially ultimately entered the police station at District 5, and where he was armed with a pistol and had a conversation with Stephen Holmblad.
Oh my God. He's dealing with his grief by taking a gun to the police station.
Longtime police officer who ironically was just weeks from retirement, as he was working the front desk at the counter at the District 5 police station. It's a public facility. There were other members of the public in the lobby at the time, seeking whatever assistance they needed that day. There were other members of the Milwaukee Police Department staff, civilian staff, actually working in the office area. It is a working office. They were all behind the counter
Singular
area,
here.
behind Mr. Holmblad, Officer Holmblad. And essentially, Mr. Parker Bell came to ask, inquire about the death of his friend. Officer Holmblad had no information to give him about it and said as much. And after just an encounter that literally lasted half a minute, Mr. Parker Bell retreated a few steps, withdrew his pistol and fired one shot into the floor. You can see in video, and this video has been public for now some time, Officer Holmblad ducks literally behind the counter and then looks up to try to figure out what should happen next. And he'll give you his own words here in just a couple of minutes. But the video clearly demonstrates then a shot fired by Mr. Parker Bell pointed directly at Officer Holmblad that literally pierces the glass between the two of them and comes within inches of striking Officer Holmblad.
He was dealing with his grief.
Devastating incident in and of itself that could have been deadly, could have resulted in serious injury, and everybody in that police station was endangered by the actions of Mr. Parker Bell. He fired another shot, which of course then really anticipated the response you would expect at that point in a police station with armed police officers, which was that another officer came out from behind and started firing shots back toward Officer Parker Bell while in the lobby of the station. At this point in time, Mr. Parker Bell left the police station and ran through an alleyway or down the street in the nearby neighborhood. He was being pursued now by a number of officers, and while still in possession of the firearm, fired no more shots, pointed the gun toward the officers, which ultimately elicited commands from them to drop the weapon. He did not drop the weapon. Ultimately, officers fired and struck Mr. Parker Bell, fortunately only wounding him, and he was taken into custody. I think it is significant, frankly, that we've known essentially from the beginning what the purpose was from Mr. Parker Bell in going in there. And essentially, he indicated his grief at the loss of his friend. He indicated his desire for his own life to end. And his method by doing that was to essentially go into the police station and fire shots in the police station, which he thought would exact the response that would result in his death. Unfortunately, it's also, of course, resulted in a level of trauma suffered by 8 individuals directly and others who might not have been in the line of fire, but certainly were in the building that day. What I would like to do at this point, I have some other comments I'd like to make related to the length of the commitment that I think is appropriate. But first, I would like Mr. Holmblad to come into the courtroom, and he's got some comments that he'd like to make to the court.
Oh, this was all unexpected. How long should he be committed? So they're saying he was trying to do suicide by a cop. It scared everybody, but he really didn't want to hurt anybody. He just wanted to get shot. Okay.
Thank you, Aaron.
Good morning. If you could start off, first of all, thanks for your patience today. If you could start off, I know Mr. Lovern told us your name and spelled it, but if you could spell your first and last name for the record.
My last name is Holmblad, Holmblad. First name is Stephen, Stevен.
Thank you very much for being here today, Officer Holmblad. What would you like to tell me today?
Well, let me just start with, I constantly think about what happened that day. That does not go away. The beginning of that incident, right prior to the incident, I should say,
Mm-hmm.
I had a female come in.
Yep.
And was making complaint about a sexual assault that had happened to her. It had happened 6 years prior by a family member, resulting in a child. As I was dealing with that, I had just come back and sat at my desk when Mr. Parker Bell came into our district.
Say thanks for this again.
He started to speak with me. I couldn't even hear him from my desk. I had to get up and get up closer to the desk so I could hear what he had to say. He asked me what had happened to his brother, and I says, I had no idea what he was talking about. He says, I don't know. Said,
He wanted to die
"Brother died
tired.
the other day." I said, okay. I knew that there would have been an incident where an in custody death. I says, first, I don't know anything about it. Second part of that is even if I did, I can't talk to you about it. This is an ongoing investigation. And that was our conversation from beginning to end. That's when he retreated and grabbed his gun and decided he was going to start shooting. Well, luckily the first round went off and hit the floor instead of at me, which caused me to duck. But what doesn't show on a lot of the other videotapes that they show on the TV was he reached his gun over the counter to shoot at me again. Then
That's
he
bad.
realized his gun wouldn't fire because it was a class 1 malfunction. It was what we call a stovepipe in the industry, where a casing gets stuck actually in the gun so that it can't recycle. He actually recycled that. He actually cleared that malfunction by scooting back and moving, actually throwing rounds out on the floor.
Nice.
By the time I popped back up to find out, and I had my gun at that point, I popped back up to look to find out where he went. He was already on the other side of the room. By then he had shot his next round at me.
Wow.
Everybody that was in that room thought at that point I got hit because it was that close to my head when it went off. I scooted across the floor, coming up someplace else. I was going around the corner. Meanwhile, he and another officer were firing rounds back and forth over the top of where I was crawling. When I popped back up, he ran out the door. He was gone. It was not just of the incident that happened that it was at me, but everybody that was in that room at the time. There was the pregnant lady that was there that was making a complaint in the lobby. There was 2 homeless people in the lobby. I had 2 civilians sitting that were office workers in our office that were trapped behind their desk at the time of this incident. All those people were in danger from what he had done. One of my biggest fears, because he will eventually come out, and I know this is nothing new, that he is going to, who is going to monitor him so that he does not go right back to what incident that we just had happen to us. Because next time he comes out, is he going to, instead of coming into a police station, is it going to be a school? Is it going to be a sporting event? Is it going to be what to cause him to go off and do this again? And when he does, who's ultimately responsible for that? I personally, if there's a hearing, I will be there. If I'm still here, I will be there. Because even though that I no longer work for the police department, I still have a responsibility to this city to try to maintain safety for all of us. For the community, for all of us that do our jobs every day. That's what I personally believe. And if there's anything that I can do to protect that comment, I will do it. And that's all I have to say. Thanks.
Thank
Okay.
you very much for being here. Thanks for your service to the community and your continued pledge to serve and protect our community. I appreciate it. Thank you.
So as to the ultimate disposition moving forward here, there's obviously no dispute that Mr. Parker Bell has suffered a lifetime of trauma, and I've certainly seen that in the reports done by 3 highly respected doctors in this case, who all agreed that that the NGI status was appropriate here. There's no question, based on the submissions from the defense, that that he's suffered greatly in a relatively short life, but throughout his entire life. He's been
they're saying he was insane,
victimized
and so he's just
personally.
going for mental
He's
commitment.
had
Interesting.
unstable family situations. He's had harmful family situations.
You don't see this too often.
He's lost
That's why they're
many
talking
loved
about
ones in his
commitment.
life.
I think.
One could say that while we see people who suffer trauma every day in this facility, it could be that for his age, he suffered a disproportionate amount of trauma relative to the number of people we see even in this courthouse setting. And that's real. And I've not ever from the beginning disputed any of that.
I think this is
What I think
NGI.
I think that underscores, though,
Not guilty,
the
insane.
fact that that a significant response is required here. You know, I know this court's aware and council's aware. There's a maximum we've said many times in the system that hurt people hurt other people, and there's no question that
They
Mr.
can.
Parker
You
Bell's
can
been
just go
hurt
watch
many,
it
many
without any
times over the
comments.
course of his life on a consistent and
Somewhere
deep
else.
basis.
How about that?
And we see this every day in our community. The upshot of that in this particular situation, of course, is that also the level of hurt caused by Mr. Parker Bell is significant here. Fortunately, not deadly. Fortunately, no serious injuries, but clearly significant. And as we think now about, and I know this court will carefully evaluate the level of trauma suffered by Mr. Parker Bell. We've also got 8 individuals now who suffered an amount of trauma as a result of his actions here, and that's got.
I think this
it's
is
important to
commitment,
take that into
not
account.
prison.
I think obviously after the 3 doctors evaluated him, and we have the WCS evaluation from Ms. Whitaker, it's clear that it's clear to the state that Mr. Parker Bell is just really at the very beginning of his treatment journey here. I think that was evidenced and spelled out fairly clearly by Ms. Whitaker in her report, indicating that he's essentially he is a significant risk of bodily harm to himself or others, or of serious property damage. Her report indicates that at this point, he demonstrates minimal insight into his own mental health diagnoses, first essentially learning of his diagnoses through this court process. And even then, I'm not sure there's a consensus yet about what that diagnosis will ultimately prove to be. As many mental health cases go, sometimes a first diagnosis isn't the ultimate diagnosis, or there can be 2 or 3 situations going on at one time that require a response. There's no question here that the volatility of his actions in February of 2022 make him appropriate for confinement in the institution and from a commitment to the institution. And what I would suggest is for a lengthy period at this point in time. I don't think, I think it's important that he recognizes it. Clearly, he said that in his interviews with the doctors, and that's a good first step, of course. And it's,
Should I not have done
only a
that?
first step of many to come before he really receives a consistent diagnosis and treatment regimen for him
Treatment
to
journey.
address the hurt in his life. So the state's position is that the lifetime of trauma suffered by Mr. Parker Bell really requires a significant period of time in a secure treatment setting at this time, and clearly period of time for intensive monitoring of his health down the road. He is a young man still, and the hope would be that even with a lengthy period of commitment within the institution and a significant period of monitoring beyond that time in a secure setting, he could still, the hope would be that he could have many good years of good health after this process of treatment and intervention that he so desperately needs. But it's certainly not something, the level of damage he suffered as identified by all of the medical professionals and by Ms. Whitaker in this case, certainly is not something that can be unwound overnight. It's not something that can be quickly or easily dispelled. And the risks to himself and others require at this time a significant amount of commitment to the Department of Health Services.
I think somebody
Under the
has already
circumstances,
bought it.
the state is recommending 25 to 30 years of total commitment time to the Department of Health
Wow, it's a long
Services.
treatment journey.
That's for the 4 counts of counts 1, 2, 3, 4
Sounds kind
of
of
the
like
amended
prison.
information. 4 counts: first degree recklessly endangering safety, use of a dangerous weapon. The court is aware of the one prior conviction he had from 2019, a misdemeanor endangering safety offense. And other than that, he has no other prior record of which I'm aware. Under the circumstances, I would ask the court to follow the state's recommendation. Thank you.
Thank you very much. Mr. Appleton-Towns.
Judge, thank you. What we're doing here today is different than a sentencing. Everybody knows that. The court knows that. What we're asking, what's to be determined today is whether or not Mr. Parker Bell needs institutional care initially or released to the community. And it is our stipulation, our agreement that institutional care is appropriate up front. And then Your Honor has to determine the length of his commitment. How long is Mr. Parker Bell going to be under the supervision, under the control of the state to get him to the point where he is no longer dangerous to himself or others? That's what we're trying to do today, not to punish him, but to keep him safe and to keep the community safe. And so we're sitting here today in 2023 trying to make educated guesses, educated speculation about how long that's going to take. To do that, I think, of course, need to look at this particular person, Mr. Parker Bell, need to look at this particular incident and what led up to it and what it was exactly, and this particular mental health issue or mental illness that Mr. Parker Bell presents with. So as to Mr. Parker Bell as a person, you've read reports, numerous psychological reports that talk a lot about his background and his history. Each report that was written referred to Mr. Parker Bell in their interviews as being polite and cooperative. He was always polite and cooperative, and I join in that. He's always been polite and cooperative with me, with the exception of very early on in our relationship when he was actively psychotic and felt that was paranoid about my presence as representing him, but he has overcome that since starting to take medications. Mr. Parker Bell, as the state just pointed out, has one misdemeanor conviction, no other juvenile or adult adjudications or convictions. He is a Milwaukeean. He has spent some time in other states for shorter periods of time, but he basically grew up here with his family, most recently living around 30th in Wisconsin. Living there with a girlfriend of his. Her name is Angel. They have a dog together. They've been living together at trying to make a house together for the time period until he was arrested. They don't have any kids. Mr. Parker Bell has no children. Mr. Parker Bell went to high school. He graduated from Bradley Tech, class of 2017. He graduated on time.
Sweet.
There's some indication that he had some IEPs in his history, but nonetheless, again, went from grade to grade until he ultimately graduated.
Yeah, but if you're insane,
he was working.
You get a treatment journey.
After graduation, he was working at the time of this. At the time this happened, he was at Batteries Plus. Before that, he has job experiences at Walmart and at a Cousins and working DoorDash as well. So he's been able to live a socially positive life, trying to get jobs, trying to maintain jobs, trying to build a household. Doesn't really have, well,
just trying to build a house.
The court can conclude whether he has a AODA problem. He has openly and honestly expressed to the evaluators that he has some history of using alcohol, some history of using marijuana and ecstasy. I don't think those are the primary motivating factors to Mr. Parker Bell's problems or anything that brought him here today. There's no indication that that was part of the equation the day that this all happened. Mr. Parker, when this all happened, it happened as described by the state. That was an accurate description of what it is that happened inside that
They've been trying to get
police station.
his case up.
Leading
up
to that, though,
courtroom for him today is lots of
to
defendants,
flesh that
but I
out a
think
little
he's
bit.
next.
Mr. Parker Bell had worked a shift that morning at Batteries Plus, had worked a full shift. His boss had expressed some concern with him because he knew that Mr. Parker Bell had just lost a friend of his, told him maybe he should take some time off. He could tell how depressed he was. He hadn't showered in about 2 weeks before then, and the voices were louder in his head than they've ever been. He went into that police station with an irrational, unreasonable goal. His unreasonable and irrational goal, driven by his mental health, was to be killed, to commit suicide by police officer, by going into the police station, brandishing a gun, firing that gun, forcing the police officers to shoot at him with the hopes that they would kill him, that he would die at the hands of the police, like he believed Keyshawn, his friend Keyshawn, had passed away. Mr. Parker Bell, since the beginning of when we've talked about this case, has disclaimed any intent to actually shoot any people. He
Oh,
was in this
okay.
lobby. I don't think that lobby is even as big as this room. And in that small room, there's about 7 or 8 people. And Mr. Parker Bell is firing that. And if he intended to fire and hit other people, it seems that he could have easily done that. His drive, his intention was not to shoot any people, but to fire off weapons and have him be shot, to have them return fire and shoot at him. He was shot at in the police station and ran outside, which I'm thankful for, because didn't put the people in the lobby in danger any longer. He was chased by police about a block away. His gun was jammed. He could not fire his gun, but Mr. Parker Bell made it clear to the police that he was still brandishing that gun and threatening to use it with them. He was showing it to him. He was saying things like, "I'll shoot," because he was still trying to be shot by the police. He wouldn't drop that gun, even though he could have. He was shot by the police and arrested. He had a bullet wound in his arm, his leg, and his back. He was taken to the hospital where he had to be treated for that, of course. At the hospital, he begged all the hospital staff to let him die there. The hospital staff was noticeably concerned about the things he was saying, his suicidal thoughts.
And now he's worried about
and
getting
how
COVID
consistent they were.
with this
And,
mask on. Come on,
the medical
people.
records from his
Please,
treatment at Freighter indicate that
stop.
they were advocating hard for a Chapter 51 type commitment rather than police prosecution, but that decision had already been made, and their hopes for a 51 was overruled. He was taken into custody.
I think that brings an attitude adjustment.
These voices, as been made clear
The voices.
in all the records, all the reports about this, these voices were compelling him. They were urging him to go in, to ask about his friend Keyshawn, and to die by police shooting, because he was worthless and because there was no reason for him to be living. The voices that Mr. Parker Bell has described, he said he first noticed them and asked his grandmother about them when he was very young, about 8 years old. And he said that she told him it's a gift from God, and that he was lucky for that. But those voices persisted for years. Mr. Parker Bell has not acted violently against other people previous to this incident where he put all these people's lives in danger. But he has not had a history of acting violently against other people because of what the voices are telling him. The voices are consistently pointing towards self-hate, towards telling him how worthless he is and that he should die. He has had a history of suicide attempts since about 14 years old. He has, I filed with the court some paperwork about people that were very close to Mr. Parker Bell who had died rather violent deaths in the months leading up to this February incident. Family, friends, cousins, his stepfather, the person who was the boyfriend of his mother for many years, died violent deaths. Milwaukee can be a very traumatic place to live if you are poor and you are exposed to the types of violence
And if you
that
leave the violent people
happens in
on
our
the
city
street
in
like
some
you do,
neighborhoods.
yeah, it is very violent.
Again, Mr. Parker Bell lost a number of people leading up to him losing his best friend, Keyshawn. And all of that added to Mr. Parker Bell's feelings of worthlessness and feelings of helplessness.
No, this is the end of it. This
Nothing
is just
else
how
that
long
he
did
could
they
do
stick him
about
in the mental house?
I want to talk about the specific mental health issues. The doctors at this point, and Mr. Laverne is correct, sometimes diagnoses evolve and change. Certainly medication regimens will evolve and change.
Remember, they
They
planned
seem
to
to
do this
settle
after
on a
Brooks,
major
but
depressive
Brooks was
disorder
still talking with his lawyer,
psychotic
so the judge
features,
said,
and
let's
that
go ahead and
seems
do
to
this.
recognize what it is that Mr. Parker Bell's going through. slightly different than PTSD or what our understanding of PTSD is, but it is also informed by those prior traumatic experiences that he had. Mr. Parker Bell, despite these voices and his concerns about them, was basically unaware that he was so mentally ill at the time. He was unaware of what his diagnosis was or his need for medication at that point. He had not had any formal psychological, psychiatric therapy or treatment to that point. Like Mr. Laverne said, this process kind of showed Mr. Parker Bell that he has this mental health problems. And since then, we've been able to watch him as he's lived in the jail, lived with this diagnosis, and begun to be presented with medications. Mr. Parker Bell has consistently been medication compliant in this matter since they were assigned to him. He has consistently expressed a remorse for what it is that brought him to be doing what he did on February 25th.
Tell you what, go check it out where I'm not
The
here.
doctors
I'll see you later.
variously credit him with, I have a quote here, has great self-awareness. He has an insight
I mean, I'm not trying to talk over these people
that
much, but
is
this is a
short in
commentary
length.
stream, so
Granted, he has not
you could just go
been
straight to
dealing
the
with
court
this mental
website
health
if you don't
for
want to
very
hear
long,
anything.
but
Sorry
is a
about that.
significant level of self-awareness. To wrap up, excuse me. What we're asking for is for an institutional care
Here we go.
initially, and for a total length of commitment for Mr. Parker Bell to be 10 years long. Of course, Mr. Parker Bell during that period will be able to apply for and hope to get released to the community, so his transition to the community continue to be supervised, such that he's safe and everybody's safe. And that's what we're looking to try and do. What's needed for Mr. Parker Bell to show that he's safe to go into the community, I think, is at this point a track record. He needs to display a track record that he is a person who is safe. We need a track record of medication compliance. We've been very good about that at this point. He's taken the medications they've given him. Mr. Parker Bell still hears voices. They're a lot quieter than they used to be. They're a lot less violent than they used to be, but he still hears voices. He still has concerns about self-harm. And that will improve with the different medications that will be closely monitored by him when he is in custody. So the right meds, we need med compliance. We need his compliance with therapy and psychological treatment to make sure that his awareness is sustained and increased, his understanding of what he needs to do in order to keep the community safe. He has a history, Mr. Parker Bell has a history of non-criminality. He has a history of non-violence. This excluded, this is a very violent situation, and I'm not trying to dismiss that as nothing. It's a very serious situation. But before that, again, his history has been one of self-harm and that feeling of worthlessness. He's got a history of supervision success in that one period of probation that was offered to him when he was convicted of his misdemeanor. That was completed successfully, and he even attained expunction of that conviction. So when he has a goal, he can successfully get to that goal. He has a history of doing that. And he needs a history, a track record of family support. He does have a history of that, and that
The Wendell
that does
Williamson
exist.
case here in
People are
North
here
Carolina,
today in
where the guy
support
was a
of
law
Mr.
student
Parker
at
Bell.
Chapel
People
Hill,
have been
and
helping
her
me
voices
to
went
get
back and
to
forth
where
with
we
that,
are
and
right
ultimately
now
went
to
down
be
the
able
street shooting
to
people. That's a very
fill in the
interesting case
context of who
this
Darrell
kind of
Parker
thing,
Bell
but
is
actually
and what he
existing.
needs. Judge, in 10 years, he'll be about 34 years old. He'll be a much more mature person than the frankly late adolescent that he is right now, and he is at the time when this happened. I think that there is every reason to believe that he will be in the period of these 10 years.
Here's your buddy. They're ready to rock.
Will continue to establish a track record
Judge
such
is
that
ready to
he will
move on,
be,
yeah.
when it's safe, released to the community. And eventually that this condition of that this commitment will terminate and he'll be able to go
he's
on
not
with
Darrell
his
Brooks.
life.
We've
in
been
a way
waiting for
that's safe
that.
for him and
Brooks
safe
just
for the
showed up a second ago. He's in the
Christina.
breakout room. So his case will be as soon as the judge finishes this dude.
I'm sorry, go ahead.
No, Judge, thank you. That concludes my comments on the reason why we think that's an
Again, this
appropriate
isn't
length of a
special
commitment.
Darrell Brooks Day. They have lots of cases, and
Mr.
Brooks
Parker
wasn't
Bell,
ready.
do you
So
wish to say anything today?
The judge will finish this one.
I
And he has Brooks
apologize for
live.
my
Here he
accent.
goes. He's sorry.
Thank you, sir.
All right, did it.
Um,
It was good.
So today, as we have outlined, the court needs to
Yeah, that was pretty
make
funny.
a finding as to whether or not Mr. Parker Bell would pose a significant risk of bodily harm to himself or others, or present a risk of significant property damage. The parties have stipulated to that, and there is overwhelming evidence in this record of that.
Yeah, live just down the street from there.
Given the violent nature here. So the
It's next to
question
the
is,
Harley
how
shop.
long does Mr. Parker Bell need to be committed under as a result of these acts? Mr. Parker Bell has pled guilty, has entered these pleas, and we're here on 4 counts of first-degree recklessly
He was
endangering
on screen a
safety
moment ago.
with the use
When
of a
they're done with
dangerous
this guy, I
weapon.
think he's the
The
next case
maximum
up.
period of confinement is 50 years combined. The state has recommended 25 to 30 years. Mr. Parker Bell and his counsel have recommended 10 years. As I look at this, the horror that's represented by what happened here can't be overstated. And
I'll create a banner.
the difficult thing for Officer Holmblad and the other people who were in that lobby that morning is that bullets do no less damage because they're fired by someone who, like Mr. Parker Bell, has these significant mental health issues. As is so often the case in this courtroom, there's just so much trauma at both tables, because there's no question that Officer Holmblad and the other individuals who were in the lobby that day have suffered significant trauma. And among the downsides of our system is we're not offering them any treatment, any help. They have to get that on their own. And I hope that they are getting it, because if I believe anything as a result of being here for the length of time that I've been here, it's in the incredible impacts of trauma and secondary trauma and our need to address those things. So there's this significant trauma there. And then I look at Mr. Parker Bell, who has no real significant prior criminal contacts, is clearly suffering from a mental health crisis. And what I'm being told is that this is a mental health crisis that was close to 10 years in the making.
somebody
If
is
he started
showing
hearing
up at
these
my house,
voices
so
and
I'm gonna go
attempted
see what that's
suicide
about.
since
good news.
2014.
Yeah, you guys won't have to listen to
It's
me.
troubling.
Maybe I'll be back in before
I mean, clearly,
before Brooks gets back.
I'll make
on
a
the
note.
screen.
I didn't count that. There's probably 10 or so people here on behalf of Mr. Parker Bell. Those folks are not just here today. They've been here pretty much every hearing. So it's
Be back in
clear
just a minute.
to me that Mr. Parker
Yeah, it's
Bell
the
has
judge
love
speaking.
and
Brooks is
support
next.
in the community. One of the things that's troubling about that is that love and support didn't make mental health services available to him. And I understand that that's not uncommon, because for some reason it's seen as a sign of weakness. And so it's just unfortunate that when he started hearing voices at 8, family members who loved him and supported him told him that it was a gift from God and not something that required treatment, because I have no doubt that had Mr. Parker Bell been connected with appropriate resources at that age, that he wouldn't be sitting here today. I also do have to note that it's hard for Mr. Parker Bell to view himself as fortunate, but he is incredibly fortunate that he wasn't killed by the police on that date, even though on that date that may have been what he wanted. it's somewhat perverse to say this, but this may be the event that turns Mr. Parker Bell's life around, gets him the treatment, and puts him in a position to be a more healthy member of the community. I think that's going to take a long time. And the level of threat that he represented to the community on February 25th of 2022 is incredibly high. As Mr. Appleton Dobbs said, we are trying to predict the future here today, which is very, very difficult. However, there are two elements to this. Obviously, Mr. Parker Bell is going to need institutional care, but under the NGI laws in the state of Wisconsin, he will eventually be able to transition into the community. Officer Holmblad talked about who's going to be supervising him and who's going to be responsible. And, Officer Holmblad graciously and generously has said he's going to continue to be involved in this. And I understand that, but there will be supervision in the community. And so at some point in time, presumably, I should say, because I presume that Mr. Parker Bell, having been given a diagnosis, being receptive to treatment, being receptive to medication, will at some point in time likely, certainly he can petition for, and it's likely at some point in the future that a court will find him appropriate for conditional release. And from this court's perspective, giving a significant amount of time for that to happen, and to make sure that Mr. Parker Bell not only gets the treatment in an institution, but also has the ability to get treatment and help and supervision outside of an institution is appropriate. And the court does take that into consideration. Balancing each of those things, the court does believe that a term of commitment consistent with that recommended by the deputy district attorney is appropriate here. On count one, the court is going to order a commitment of 7 years and 6 months. On count two, the court is going to order a commitment in the length of 7 years and 6 months consecutive to the time in count one. On count three, the court is going to order a commitment in the term of 7 years and 6 months consecutive to the time in count one and two. And on count four, the court is going to order a commitment of 7 years and 6 months consecutive to the time in counts 1, 2, and 3 for a total of 30 years. Now, that does not mean that Mr. Parker Bell will be institutionalized for 30 years. What it means is that Mr. Parker Bell will get the help that he needs for the next 30 years. And I think that is appropriate. That's appropriate to give him the time that he needs, the treatment that he needs. And it's also appropriate for the community because the impact of what Mr. Parker Bell did, obviously it impacts Officer Holmblad. It impacts the people who were present in that police station that day, but it also impacts tremendously our entire community. I mean, think about the young lady who came in to speak to Officer Holmblad to report that sexual assault. She went to the police because the police station should be a place of safety and a safe harbor for people in our community. It's a people that we can turn to when we are in trouble and when we feel threatened, when we feel in danger. And on that date for that time period, Mr. Parker Bell shattered that sense of safety that we should feel. And I'm not naive enough to not understand that not every member of our community feels that way when they go into a police station, but that's the goal, that's the purpose, that's what every officer is there for. And like any human endeavor, it's not perfect. That's what we're striving for. But what Mr. Parker Bell really did that day takes greatly from the community. So that's another reason why I think that length of commitment is appropriate. So that is a total of 30 years. That he doesn't have any other sentence.
I thought they'd be
So
done
that
with this by
commitment
now.
is effective today. You'll calculate his
I just saw the
pretrial credit
chainsaw in the time
Mr.
it took to
Ocklendoff,
listen to this.
464
to today or to yesterday.
to yesterday to the.
So 464 days credit against that. Because these were felony offenses, Mr. Parker Bell, you can never possess a firearm. They were violent offenses. You can never possess body armor. And those restrictions remain throughout. Good luck to you and your family. You've undergone incredible amount of trauma. I know that no one would ever want to be sitting in your chair facing what you're facing, but you have an opportunity to use this as the moment that turns your life around in a positive fashion. Because I know the deputies don't like it, but you'll see them when you walk out. You'll see the number of people who are here to love you and support you because they know that you have worth and you'll continue to have worth, and they're going to be there for you. And I hope someday you recognize your own self-worth, so that you're not driven by these voices, driven to self-harm and the harm of other people. Good luck to you and everyone. Thank you very much, Mr. Parker Bell. Thank you. So let me know if that makes sense. Okay.
Yeah, going to a secure facility is not a picnic, that's for sure. All right, it's go time. He got his glasses.
Okay.
Sorry, I was loud. Go back to golf mode.
Yes. All right. So he obviously is committed to a state facility for that length of time. All right. All right. Good morning again, Mr. Brooks, Mr. Rakestraw.
Here.
I think we may have sent Mr. Hampton to another court.
Okay.
But my understanding is that the parties have reached a resolution on Mr. Brooks's case.
That is not the case, Your Honor. It appears that we are, as of right now, are still on for trial.
Okay.
Wow.
I would ask that the state, if they're willing to leave that offer on the table until the day of trial, Your Honor.
All right. Well, this matter. This is State of Wisconsin versus Darrell Brooks. Can we look these folks up? Case 20 CF 2550. Appearances?
It appears by Jacob Court. Good morning, Your Honor.
Darrell Brooks appears by attorney William Rakestraw, Your Honor. Good morning.
Good morning. We're on the calendar today for final pretrial. The records reflect that Mr. Brooks was produced from Dodge Correctional. However, there was a staffing issue in the jail. And all right, I'm sorry, Mr. Hampton, are you going to appear?
Yes, Attorney Hampton also appearing with Mr. Brooks. Good morning, Your Honor.
Good morning. I apologize. I thought I'd lost you to another court. We're on the calendar for final pretrial. Mr. Brooks is appearing via Zoom. Mr. Hampton's in the courtroom. Mr. Rakestraw is appearing via Zoom. I had put Mr. Brooks and his lawyers into a breakout room. And then this was delayed because there was another hearing that I needed to call. Mr. Brooks's case is set for trial on July 10th. Mr. Rakestraw has informed the court that Mr. Brooks is still in trial posture. Mr. Cord, does the state anticipate being able to go forward on July 10th?
Yes.
All right. I know there had been discussions and there was a request from Mr. Rakestraw that the state leave an offer open. Can we make a record as to what that offer was?
Judge, I was, count 1 and count 2 were going to be dismissed. Count 3 would be pled to. I believe the recommendation would be a prison sentence determined by the court.
With defense free to argue.
Correct.
All right. And just for the record, Mr. Brooks, are you aware that that's the state's plea offer on this case?
I am, Your Honor.
Okay. So at this point, we're set for trial on July 10th. Is there anything else we need to address on today's date?
Judge, only that if this case were to resolve, I would ask if I could get notice maybe the week before, just so I don't have to bring in my witnesses. We don't have to have another court date scheduled, but if I could get notice from Mr. Brooks and defense counsel that that's where we're going, I would appreciate that.
I would appreciate it as well. This court will be down the week before, but if you can communicate with the court via email, because I anticipate that if we go to trial, I'm going to have to make some arrangements because I don't, there's a limit to the number of people we can bring over to this courtroom for voir dire. I think that we may need to conduct voir dire with a larger pool than I would ordinarily do. And so I'm going to have to make arrangements on that. So the more advanced notice we have, the better. Anything else we need to address today, Mr. Core?
No, Judge, thank you.
Mr. Rakestraw, Mr. Hampton?
No, Your Honor.
All right. Thank you very much. We'll see everybody July 10th. Thank you.
So I'm going to mute the court there for a moment. So this is what I heard, is that the state had offered to drop the first 2 counts, which are both reckless endangerment, and he would plead guilty to the 3rd count, which was possession of a weapon by a felon. So I'm not sure why that didn't conclude. It seemed like the lawyer thought that it would, but it didn't. But he asked the state to keep that offer open. So this is supposed to go to trial next month, but you know, it's looking like with the state willing to drop both of those charges just in exchange for the possession, that this would potentially resolve. And you saw Brooks nodding his head up and down like he thought it would too. So I'm not exactly sure why they haven't finally concluded it at this point, but so that would just leave Erica's cases after that. So anybody got any questions on what happened with that? We did get an interesting experience with a not guilty by reason of insanity case before that. Well, it could be lots of reasons for that. You know, in a plea deal, a lot of times you do drop charges, and as people have said, ultimately it doesn't matter because of his life sentences. So, and the witnesses may have said, yeah, I'd just soon be done with it. You know, who knows? Lots of reasons for that. It was interesting. I don't know that it shined any light on what he's going to do on Erica's cases, but a lot of air out of the balloon on this one, that's for sure. You know, this Parker Bell dude, every time they say that, I keep thinking about King Charles, I guess you have to call him now, and the new queen, Parker Bowles. I like how this dude's appearing here. I almost want to listen to it, but so everybody, if you do want to watch these cases, you can just Google this Wisconsin Circuit Court live streaming, and then you find the court you want to watch. And if they're streaming, you watch it. And there we go. So I think that's it for this. We went over some of the other things and stuff, and hopefully see a lot of you guys at the end of the week at the weekly docket. I think I got the poll ready to go based on what I saw earlier. And we'll see if I can fire this puppy up. Thanks for dropping in.